Hello, everybody. This is Jim Kenzel. I am with the American Supply Association, and welcome to our ASA Safety Committee webinar, OSHA's General Duty Clause, What You Need to Know. And welcome to our presenter, Brad Hammock. Just some logistics for you. First, I'd like to recognize all of ASA's supplier partners. It is because of our supplier partners and the folks you see here on the screen right now that we are able to provide our members and the industry as a whole these type of seminars free because of their financial support throughout the year and their commitment to ASA and our wholesale distributor members and the industry as a whole. And we just want to thank them. And please, if you're talking to any representatives from these companies at any time, please feel free to pass along your thanks as well for their support of ASA. So we will, the presenters will be the only ones who have ability to speak. You will be on mute throughout the presentation. However, I encourage, if you have any questions for Brad as he starts his presentation, to enter those questions in the question box or entry area that should be in your view screen. And I will be monitoring and looking for questions as you enter them, and we'll be feeding them to Brad throughout the presentation. So never hesitate anytime during the presentation to write down your questions, and we'll be sure to address them before the presentation is over. So I want to welcome Brad for joining us here. Brad is a tremendous expert in the area we're talking about. And we were able to reach out to Brad after one of our staff people heard him give a presentation in Washington, D.C. and recommended him to us and for our members. So we are thrilled to have him. Brad's focus areas are workplace safety and health, along with Workplace Policy Institute. He is a shareholder with the firm. Oh my gosh.
Tough to pronounce. Littler Mendelson.
There you go. Thank you. You don't, there it is, Littler. Okay. I'm sorry. Brad's national practice focuses on all aspects of occupational health, safety and health law. In particular, Brad provides invaluable assistance to employers in preventive practice, including conducting full-scale safety and health compliance audits, reviewing and revising corporate safety and health policies, conducting manager and supervisor training on employee safety and health. Brad works closely with employers to help them understand and implement safety and health management systems. In addition, he represents employers throughout OSHA rulemaking proceedings, including OSHA's informal public hearings on proposed rules. Brad also defends employers against OSHA enforcement actions and the like. For an employer that is the target of an OSHA inspection, he offers representation from the start of the inspection through settlement or litigation. Prior to joining Littler, Brad was the Washington, D.C. regional office managing principal of a large national firm representing management and workplace law matters. He was previously an OSHA attorney with the Department of Labor, serving as lead counsel for safety standards. Brad is widely regarded as one of the nation's most knowledgeable attorneys on the topics of OSHA record keeping, crystalline silica, and ergonomics. Brad, welcome. And wow, what a background. And we're all anxious to hear what you have to say. So with that, Brad, I'm going to change it over so you have the screen.
Great.
And you can go run with it. So verify. There you go. It should be coming your way.
Great. I hope that everyone's able to see this now. Jim, I'm hoping that all our listeners can now see my screen. We've worked through that major technical the complicated technical aspects of the handoff. So thanks everyone for joining.
If people are not seeing Brad's screen, please let me know in the question box and we'll take care of it.
Yeah, absolutely. And thanks, Jim, for that introduction. And it is a pleasure to be here. I'm glad you were able to reach out to me, and certainly welcome the opportunity to talk to you and your members on what is really an important issue. And it's just even more important in the age of COVID-19, and that is OSHA's general duty clause. Over the last several months, I've given a number of presentations specific to COVID-19, a number of webinars, and I'm sure all your members have also listened in to a number of different webinars on that. It is certainly monopolizing the country, workers, employers trying to navigate through the pandemic that is ongoing, sort of continuing, even today. And so it's interesting to talk about this presentation, the general duty clause, because it has been a hot topic over the last several months with respect to OSHA and what are the various tools that OSHA has at its disposal to potentially enforce various preventative measures implemented by employers with respect to COVID-19. I think everyone knows that there is no specific federal OSHA standard related to COVID-19, although the state of Virginia just passed a standard on that. But OSHA has pointed to its ability to issue citations to employers under the general duty clause for failing to take certain actions with respect to COVID-19. And so this presentation about the general duty clause generally is really timely, and I hope will be helpful to everyone listening as you try to navigate your way through COVID-19 as well as other things. I will say this is not going to be a COVID-19 webinar. So we are going to touch a little bit on COVID-19 at the end and discuss how that specifically relates to the general duty clause and what OSHA is thinking about in terms of potential application of the general duty clause to COVID-19 cases. But this is not going to be solely about COVID-19. But what are we going to do? We're going to do a pretty thorough deep dive into what's called the general duty clause. What is this thing? Many folks who are listening probably are familiar with it, have heard of it, maybe been cited by OSHA for a violation of the general duty clause. So we're going to really kind of dig into what it is, give a little bit of the background of it as well. And that's really important to understand how Congress in particular, when it included the general duty clause in the Occupational Safety and Health Act of 1970, really wanted it to be limited. It did not want OSHA to use it very often. And so we'll discuss a little bit of that background to try to provide a little bit more of the sort of the atmospherics of the general duty clause and how it's applied. And then we're going to go into the nitty gritty, I call proving a general duty clause violation. One of the things that the courts have held with respect to general duty clause cases is OSHA has a more exacting burden of proof. OSHA has to prove additional things with the general duty clause that it wouldn't otherwise need to prove. And so we'll talk through a little bit about that. And then finally, we'll focus on what I call the 3 or 4 big key areas of focus for the general duty clause in OSHA. What are those things that we see time and time again, OSHA citing employers for and using the general duty clause? And how does that relate to your operations? What are the things that you need to be thinking of to avoid a general duty clause violation in those areas? So a lot to focus on for sure. But look forward to getting into it with you. Obviously, as Jim said, also, if you have any questions, type them in. We'll try to get to them throughout. Have some natural breaks and try to deal with as many as we can. Okay, so let's get going. What is the general duty clause? What is this thing that we're talking about when we talk about the general duty clause? Sort of what does it mean? Okay, So if you think about your OSHA obligations, right, what do you have to do to ensure a safe and healthful workplace, right? They essentially fall into two buckets. One are OSHA standards, okay? We're all familiar with OSHA standards: machine guarding, lead, bloodborne pathogens, lockout, tagout, all the different things, all the different rules that OSHA has specifically promulgated. Those things are called OSHA standards. And obviously, when you're as an employer, you have to be aware of those that are applicable to your work environment, and you have to comply with them, right? OSHA standards. So that's one piece of the puzzle. Now, there's a section of the Occupational Safety and Health Act, which is the statute which created OSHA, which provides for employer compliance with those standards. And that actually falls in what's called Section 5A2 of the statute. All right, it's the only time we're going to talk about Section 5A2. But it essentially says to employers, look, if OSHA promulgates a standard that's applicable to your work site, you have to comply with it. Okay, that's Section 5A2. So that's the one piece of your compliance obligation. The second piece is the general duty clause, okay? And that is contained in Section 5A1 of the statute. Okay, so a lot of times people will talk about the general duty clause, and they talk about it in terms of a 5A1 violation, right? It's the same thing, okay? What that particular provision says, 5A1, is that each employer shall furnish, and it's here, essentially each employer shall furnish to each of his employees a place of employment free from recognized hazards that are causing or likely to cause death or serious physical harm to your employees, okay? It is an overall catch-all provision. It essentially says that, look, you have to comply with OSHA standards, that's in 5A2, but otherwise, okay, you have to ensure that your employment is free from recognized serious hazards, okay? That sort of vague language, a sort of ambiguous obligation that everyone has, okay? And we'll talk a little bit more going forward about what that actually means and how that fits together when we get into the background on the general duty clause. But I want to just sort of emphasize at a basic level those two obligations, and those are the principal obligations from a compliance standpoint that all employers need to focus on. The one thing I would mention as well, before we get into some of the background and the legislative history on this, is that the general duty clause only applies to serious hazards, okay? It does not apply to non-serious hazards, to state the obvious, right? Only serious hazards, those that exist that could cause death or serious physical harm, are what's covered by the general duty clause. If there is something in your work environment, maybe it gets a paper clip, gets something that gives you a paper cut or something like that, that's not a serious hazard, and therefore the general duty clause wouldn't apply to that. So it's important to keep that in mind when you think about your overall obligation. Okay. That just sort of sets the stage about what we're talking about, right? So you're an employer out there, you've got to comply with Section 5A2. You've got to comply then with Section 5A1, which is the general duty clause. Okay. So let's talk a little bit about what brought on the general duty clause, because, and not to get too much in the weeds about legislative history and sort of the legal background here, but there is kind of a bit of a history here with the general duty clause. And basically when Congress was setting out the statute, they came pretty quickly to the conclusion that, look, OSHA is not going to be able to promulgate a standard dealing with every single conceivable hazard that exists in the work environment, right? Just not going to be able to do it. So as a result, they decided, you know what, we have to have some sort of catch-all provision out there, something that's out there that would allow OSHA and then obviously force employers to take action to protect their employees in those instances where OSHA doesn't have a standard, okay? And so they came to that conclusion pretty quickly, and they decided, therefore, we need this thing that has come to be known as a general duty clause, right? OSHA standards are out there, but employers still have to have this general duty to protect against known sort of recognized serious hazards. And that is the way the two fit together. And as we talk throughout the course of this webinar into those areas, they are sort of a yin and yang, right? So OSHA, as a general matter, will not issue a general duty clause violation for a hazard that's otherwise covered by an OSHA standard. So they sort of fit hand in glove there. To the extent there's a standard, that's what an employer needs to comply with. To the extent there's not a standard covering a hazard, that's when the general duty clause potentially kicks in. Originally, the general duty clause was actually urged in Congress by the National Safety Council, right, which is obviously still in existence and one of the leading safety organizations out there. And they basically flagged what was the core issue for Congress, right? Look, OSHA can't come up with all of these safety and health standards that are out there, right? So you have to have some sort of general obligation to provide a safe and healthful workplace. And they said the absence of such a general obligation provision would mean the absence of authority to cope with a hazard condition which is obvious and admitted by all concerned, but for which no standard has been promulgated. So they were the ones that were urging it in the first instance. And I want to focus a little bit on that language, obvious and admitted, right? Because that ends up being a sort of a theme and a thread, both with Congress implementing the Occupational Safety and Health Act, but also just generally how the general duty clause is supposed to be limited. It was very important for a lot of folks who were crafting the Occupational Safety and Health Act that the general duty clause be limited to those things that were obvious and sort of admitted by everyone concerned, as the National Safety Council said, right? You got an obvious hazard in your workplace. Everyone knows it's a hazard. You walk in your workplace, it sort of hits you in the face. It's an obvious hazard. There's not an OSHA standard about it, but as an employer, you should be doing something about it, right? And that is kind of what the underpinning was for the general duty clause. And unfortunately, we see in many instances, OSHA, as we'll talk about a little bit later on in the webinar, has applied it in areas where it hasn't been obvious or admitted all around. And that's where the difficulty of compliance comes. But it started with that sort of testimony from the National Safety Council. So ultimately, Congress adopted the general duty clause. There was a lot of debate back and forth, but they ultimately agreed to this idea that, look, OSHA is going to come up with standards, but you have to have something other than that, some sort of general duty. And so they came up with a general duty clause, and they specifically included some language in there that is important, certainly important today. And we've talked about that a little bit. The idea of recognized serious hazards. That's what the general duty clause covers, right? And it pulls in those things that the National Safety Council was talking about, as well as other members of Congress, right? The hazard has to be serious, it has to be significant, right? Sort of admitted, as we talked about. It also has to be recognized. And that is a very key point. It has to be recognized by the employer or the employer's industry. And we'll talk through a little bit more about how that plays out when we move to the next discussion about proving a general duty clause violation. But the reality is it can't just be something that no one knows about. Congress did not intend application of the general duty clause in those situations. It has to be a recognized hazard, it has to be serious, right, in order for OSHA to use the general duty clause. I think as a general matter, it's also important to point out that Congress intended, this provision to be narrowly construed. They did not want employers to be faced with civil penalties for hazards or conditions that weren't obvious and where abatement wasn't absolutely clear. And so Congress intended the general duty clause to be used rarely, frankly. The hope was that OSHA would come out with standards, and it would only be used in these rare circumstances where it was so obvious and the employer wasn't taking any particular action to address it. Okay. So we talked a little bit about what the general duty clause is. We talked a little bit about the background on the general duty clause and why it came about. Okay, now let's move a little bit to proving the general duty clause violation. And that's where sort of the rubber hits the road. Okay, so you're in the middle of an OSHA inspection. OSHA comes in and is looking at your work site. And maybe you violated a couple standards, hopefully not, right? But maybe you violated a couple standards. And then in the course of the walkthrough, or the course of talking to employees, the compliance officer learns of a hazard out there to which no particular OSHA standard applies, right? In that situation, what the compliance officer would do, to the extent they want to issue a citation, is to issue a general duty clause violation. And we'll show some examples of what those violations look like a little bit later on in the webinar. Okay, if the citations are issued, in order for them to be sustained, okay, if an employer were to challenge it in some way, the OSHA, I'm talking to the Secretary of Labor or his delegee, OSHA, has to prove four things, right? The first is that a hazard exists in the first place, okay? That there actually is a hazard there. I mean, the compliance officer goes in, sees something that he or she thinks is problematic. Well, is it really a hazard? Okay, that's the first thing. The second thing the secretary has to prove is that the hazard was recognized by the employer or the employer's industry. Okay, so it was actually a known thing, known, obvious, all those terms we talked about, right? All of those things, the secretary has to prove that as well. That's number two. Number three, the secretary has to prove that exposure to the hazard would result in serious harm. We talked about that already as an element of the general duty clause. So if you're an employee, you get exposed to this hazard, it's going to result in serious harm. It's not going to result in a paper cut that you just put a Band-Aid on, right? Serious harm of some sort. The secretary has to prove that. And then finally, and sometimes, this is probably the most controversial aspect of a general duty clause violation. There has to be a feasible means of abatement that exists out there that would eliminate or materially reduce the hazard, okay? So a feasible means of abatement has to exist that would eliminate or materially reduce the hazard. And the secretary has to prove all those things. If the secretary doesn't prove all those things, then the general duty clause violation fails. So general duty clause violation cases for OSHA are not easy. They're not easy at all, as a matter of fact. They have to prove all of those elements. Oftentimes, they involve expert witness testimony. So it's not easy at all from an OSHA standpoint to prove these violations. And that's why in some measures, they can be, they're still sort of rare. And certainly, as I said, difficult for OSHA to prove, for sure. Okay, what I'd like to do is sort of break down each of these elements a little bit further before we then segue into what what an actual scenario looks like in terms of the key areas of focus of OSHA. Okay. Now, first, OSHA's got to prove the existence of a hazard. Okay. Generally, as a practical matter, this is the easiest element for OSHA to meet, right? And it says here often that the hazard is self-evident. In many instances, a general duty clause violation will occur when will be issued when there's an accident or an injury, sometimes a fatality, where OSHA comes on site and sees that something happened bad, obviously, and so the hazard there is sort of self-evident, right? Something fell, for example. There was a hazard there, a rack fell over, something like that, So a lot of times for OSHA, the existence of a hazard is fairly easy to meet in the first instance, particularly when there's an accident or injury. The one thing to keep in mind, though, in some of the areas which we'll talk about before, OSHA's got to define the hazard in a way that provides employers notice of their obligations, okay? And this does come up at times in some of the cases that have examined the general duty clause, right? The idea is that the hazard's got to be defined in some way. And so I give examples there of ergonomics and heat illness, right? And we'll talk in more detail about those two areas because they're some of the most controversial with respect to the general duty clause. But in those areas, it's actually very hard to define the hazard in a way that provides employers notice of their obligations. For example, with heat illness, at what level does heat constitute a hazard? And what is the definition of that? I mean, in some cases, OSHA has alleged that once the temperature, the outside air gets above 81 degrees Fahrenheit, at that point, the heat is a hazard, which could be cited under the general duty clause. Well, there's a lot of variables in that. I mean, 81 degrees in the South right now is a daily occurrence. So, it can be challenging in that sense. And particularly in some of these areas, which we're talking about in ergonomics and heat illness, where it may be a little bit harder for OSHA to actually define the hazard in a way that provides notice to employers. So it's important to keep that in mind in terms of the elements of the general duty clause, improving that first thing. But in certain sort of, let's call it run-of-the-mill general duty clause cases, generally the hazard itself is sort of self-evident and it's fairly easy for OSHA to prove. Okay, so that's the first element there. That's the first element there. I'll stop there. Jim, do we have any questions before we move to some of these other elements?
Brad, right now we don't have any questions, but just a reminder to everybody that if you do have questions, please enter them into the question box. And as Brad mentioned, he'll be stopping periodically and asking me this question. So just a reminder, enter your questions if you got them.
I won't. I'm not offended. I never get offended. I just assume that the material is crystal clear, and so no one has any questions. So, okay, we talked about sort of proving the existence of the hazard in the first one. Okay, the next one, which is getting even trickier than the first one for OSHA, is recognition of the hazard. Okay, this goes back to the obvious concern thing. Folks there has to be overall recognition that this thing that we're talking about is a hazard, okay? Now, there's two ways for OSHA to prove recognition. One is that the employer, folks listening to this actually recognize the hazard, regardless of what the industry thought of it, right? In other words, the managers, the supervisors, the employers at the facility, they all realized that this thing was hazardous, right? Everyone knew it, okay? What are the things that OSHA looks at in terms of proving employer recognition, right? Well, they're going to look at policies, procedures. Do you have a policy to protect employees against hazard X or hazard Y? Safety committee minutes, right? Do you have a safety committee at your work site that identifies certain hazards? Oh, this racking has been dangerous. We've noted this has been dangerous for the last 6 months, right? Self-audits, okay? That's another thing that OSHA looks at. Do you go around auditing and you say, look, these stairs have been a hazard since, for the last 6 months, right? Whatever it is, that sort of recognition within the company, within the work site, that a hazard exists that we're talking about here. Training. Do you train your employees in the hazard, right? Be careful of X, Y, and Z. Okay, that's another thing that goes to employer recognition. And then finally, and probably most directly, is injuries and illnesses. Okay, OSHA, as everyone knows, when they conduct an inspection, will look at your injury and illness logs, right? Your OSHA 300 logs. That is if there are injuries or illnesses caused by the hazard at issue, that is going to be sort of first, number one, significant evidence by OSHA for employer recognition. I mean, just to get on a tangent, as off on a segue, one of the most important things you do is if you have injuries and illnesses, they're on your 300 log, you have to make sure you close the loop and address any hazards that exist that cause that injury or illness. Otherwise, you're really opening yourself up, obviously, to a violation of a standard but also a violation of the general duty clause potentially. So that's important evidence of employer recognition. So if OSHA comes in and finds the hazard, establishes that hazard, they're going to probably try to look to see if the employer, the company, recognized the hazard, and they'll look at these things in trying to make out that case. Okay. Now, what they may do, they could look at all those things and they could say, you know what, I don't have any evidence that this employer actually knew this was a hazard. All right, that happens sometimes, right? There's no injuries and illnesses, there's no event, there's no safety committee, whatever it is, right? There's no evidence out there. So at that point, OSHA can prove recognition through recognition by the employer's industry. Okay, it's called industry recognition. And it's sort of, if you think about it, it's OSHA's way of saying, look, if you're an employer that just sticks their head in the sand and isn't being proactive on safety, well, we can still cite you under the general duty clause if all your peers, all your competitors have recognized this as a hazard and have taken steps to deal with it, right? That's called industry recognition. Okay. How does OSHA prove industry recognition? Well, they do it in a few different ways. First is generally referred to as industry standards, okay? Many folks who are listening are probably members or companies are members of various types of standards producing organizations, right? Industries sometimes get together and they'll publish best practice documents, industry standards for publication, and put that out there for the industry to use to improve their safety and health in their work site. Those industry standards are great documents. They're very important, but they also are primary evidence that OSHA can use to prove industry recognition. If OSHA says, look, your industry all got together, the leaders in the industry got together, they noticed that this was a hazard, and they put out this document saying this is what you need to do to address it, that's significant evidence, and OSHA will use that to prove industry recognition. Industry guidance material on the same line. Sometimes OSHA will look to information put out by trade associations, right? Trade associations are active in informing their members about precautions to take and deal with certain things. That can also be used, and I've seen it be used by OSHA in the context of a general duty clause citation. So important to keep that in mind as well. Also, knowledge of actions taken by similarly situated employers. If you got a competitor across the street and OSHA stops in and says, hey, I see you've noticed this is a hazard. Have you talked to, company ABC over there about it? Yeah, sure. Everyone knows about this. That kind of evidence can be used as well. And so all of those things are things that OSHA looks at to prove industry recognition. The one thing I would emphasize here, and this certainly we'll talk about towards the end with COVID-19, government guidance, right? OSHA guidance on a topic cannot be used to establish industry recognition on its own, okay? It can be used in combination with other pieces of information, but not on its own. So, for example, OSHA a decade or so ago came out with a bunch of guidance documents related to ergonomics, right? Guidance for the poultry processing industry, for the long-term care industry. That document on its own can't be used to establish industry recognition of the ergonomic hazard that they dealt with, right? So it's just important to keep that in mind. We'll see that when we talk about COVID-19 and CDC guidance. OSHA has instructed its compliance officers to look at the CDC guidance for establishing hazard and feasible means of abatement. But that in and of itself can't establish a general duty clause violation. Okay. So we've gone by the proving the existence of the hazard in the first place, and then recognition of the hazard. Two of the first four prongs. Okay, there's two more. The third is exposure to the hazard. Okay, this is again kind of in the bucket of the first one, right? Which is fairly easy for OSHA to prove. Having exposure to a standard is something that OSHA's got to prove both for violations of 5A2 OSHA standards as well as the general duty clause. I mean, were there actually employees that were exposed to this hazard? Let's say, for example, there's something on the very roof of a skyscraper that is a hazardous condition. But guess what? No one has gone up to the roof of that skyscraper in 2 years, right? Well, even if there's a hazard there, and even if it's recognized by the industry, if there's no employee exposure, no employee went up there in 2 years, then OSHA can't make out the general duty clause violation, okay? So that's the important thing to keep in mind. There has to be an employee that was exposed to the hazard, and OSHA has to prove that. Now, again, one thing I said in the beginning was that, as a general matter, a lot of times OSHA is going to issue a citation, general duty clause citation, after an accident or an injury of some sort. So in that situation, you're almost always going to have some sort of exposure because an injury occurred. And you're also going to have some sort of serious harm because, again, an injury occurred. So a lot of times that's one of the more easy things for OSHA to prove in the context of carrying forth a general duty clause citation. Okay, so that's the third. And now we're on to the fourth and final. And this is where a lot of cases get hung up, to tell you the truth. This is where a lot of cases get hung up. OSHA has to prove that there are abatement measures that have not been taken by the employer that will eliminate or materially reduce the hazard, okay? That's key, right? If there is an abatement measure out there that might reduce the hazard just a little bit, right? Just a little bit, then the OSHA cannot make out a general duty clause violation, okay? And we'll see how that plays out in practice when we go through some of the examples going forward. But it's a really critical limiting factor on OSHA. In order to make out a general duty clause violation, the hazard's got to exist. It's got to be recognized. It's got to be exposure. But look, there's got to be something out there that it was not done by the employer that will eliminate or materially reduce that hazard. And that is oftentimes very difficult for OSHA to prove. And just to give it a sort of immediate example, let's take heat illness, right? If you've got a hot day, let's say it's 95 degrees, a feasible means of abatement might be to provide water to employees. Well, OSHA's got to prove that providing water or providing shade or providing a break or doing whatever will materially reduce that hazard of the heat. And that's where it gets tricky sometimes because OSHA's got to bring in an expert or something along those lines to prove that case. And so that this fourth prong is oftentimes difficult for OSHA to prove, along with the industry recognition piece of it as well. Okay, so that's a lot of good sort of like basic information. What is it? What's the background on it? And then what does OSHA have to do to prove a general duty clause violation? Okay. Now, how does it work in practice? Where is OSHA going, right, with respect to the general duty clause? Where do we see a lot of attention being paid? And there's basically about 3 or 4 now with COVID areas where we see some general duty clause violations. So I want to segue into those areas now. We'll see how these general duty clause violations are set out and play out. But also, as you're sitting there listening to this and you're thinking to yourself, okay, if I want to protect my company from a general duty clause violation, what are the key areas that I need to focus on? And those are the areas that we're going to be talking about now. Okay, first and foremost, ergonomics, okay? Ergonomics, this is the science of fitting the job to the worker, right? And many folks who have been in the safety and health space remember that OSHA tried to come out with an ergonomics standard years ago. That was actually back when I was still a lawyer with OSHA. Ergonomics is that science, fitting the job to the worker in order to prevent what are called musculoskeletal disorders, MSDs, things like tendinitis, carpal tunnel syndrome, shoulder pain, back pain, those sorts of things. The theory is, in OSHA's view, that if you do certain tasks repetitively and with a certain amount of force, etc., then workers can develop musculoskeletal disorders, okay? Now, there's no ergonomic standard, as I alluded to. So as a result, OSHA has to issue citations to employers under the general duty clause. And this is an example of a citation, a general duty clause citation, just for everyone to see, related to ergonomics. I took this out of a citation that's available. The employer did not furnish employment and a place of employment which were free from recognized hazards likely to cause serious physical harm to employees, in that employees were required to perform manual tasks involving ergonomic risk factors, including but not limited to excessive force and exertion, repetitive motions, and awkward postures, resulting in ergonomic stressors causing MSDs. So in the course of that, you see sort of a lot of the elements, everything but abatement, that OSHA is asserting exists, right? The hazard itself is performing manual tasks involving risk factors, right? Employees are exposed to that, right? And they cause musculoskeletal disorders, which OSHA asserts constitute serious harm. So that's what an ergonomic citation looks like. And they're very common because, OSHA, again, doesn't have a standard to address this. Now, in these citations, OSHA will talk about and list, and that they have to do this in every single general duty clause violation, list what they consider to be feasible means of abatement. And the way that the citations are issued and written, they will basically list a number of different abatement measures that an employer can consider implementing and that OSHA contends is feasible. So some of the things in the citation that I just pulled off and read from were, you could have a written ergonomics program. You could have engineering controls, training, job rotation, medical management, early reporting of signs and symptoms of MSDs. All of those are listed as potential means to abate the hazard that we just talked about related to ergonomics. Now, if OSHA issues this citation, they would need to prove that these means of abatement will materially reduce the ergonomic stressors that were identified in the citation, right? Ergonomics programs, engineering controls, medical management, training, right? They have to prove that all of those things will result in material reduction in the hazard. And frankly, there have been cases that have gone both ways. OSHA hasn't been able to make that finding because ergonomics is so complicated in many individual instances. But that's kind of the way that an ergonomic citation looks. If you're an employer here, and just as in terms of a take home, if you do have repetitive tasks in your work environment, you are going to want to sort of take some of these measures to protect your employees, to sort of protect against an ergonomics general duty clause citation. The main thing is to have a written ergonomics program. If you've got repetitive tasks, if you're seeing on your injury and illness logs, back injuries, carpal tunnel syndromes, those sorts of things, you're going to want to probably assess what you're doing, put together a written ergonomics program to try to head off any type of ergonomics general duty clause citation. Again, because we see that, so frequently, it's just one of the more frequent citations that we see in the general duty clause sphere. Okay. The second area is workplace violence, and we're seeing this a lot more, obviously in certain healthcare industries, long-term care, but we're seeing it in other industries too. Workplace violence. Here again is a sort of cut and pasted from a citation. Employer did not furnish employment free from recognized hazards that are exposed to workplace violence. In terms of their regularly assigned duties, exposing them to and likely to cause death or serious physical harm. So workplace violence is another issue, whether that is if you're in healthcare, if it's like a patient to employee violence, and long-term care resident to employee violence. If you've got a manufacturing facility, it could be employee on employee violence. It could be someone, a stranger coming into the facility and committing some sort of workplace violence against the employees. All of those things could be covered by the general duty clause and a workplace violence, citation here. Again, we're seeing a lot of them as much as we can, but it's another area where there's no specific OSHA standard, and so OSHA has to go at it through the general duty clause. In terms of feasible means of abatement, just like the ergonomics citation, there are a number of listed feasible means of abatement that exist in these general duty clause violations for workplace violence. Just a few here: workplace violence prevention program, workplace design, training on workplace violence, taking steps to make sure employees do not work alone, establishing a rapport with the local police department. All these are sort of best practices that are out there for employers in protecting employees against workplace violence. OSHA typically includes them all, sort of like a big kitchen sink thing, just throw them all in there in terms of feasible means of abatement. And again, if it were to go to in front of a judge or something like that, OSHA would need to prove that each of these means of abatement would materially reduce the hazard. On both of these, both the workplace violence front as well as the ergonomics front, I do again want to emphasize a program. If you're worried about this, if you're having incidences or you're worried about ergonomics, workplace violence, in both instances, put together a written program. It will really put you in a good spot should OSHA conduct an inspection and open a general duty clause, potentially to issue a general duty clause violation. Having those written programs are really important. You really want to be able to show to a compliance officer, hey, we've thought about this. We've thought about workplace violence. We have a team in place. Here is our written program. Go look elsewhere, right? So in both the areas of ergonomics and workplace violence, that's really, really critically important. Third, heat illness. Okay, I've already alluded to, some difficulties with respect to heat illness. OSHA has issued a number of 5A1 violations in this area, mostly I will say in the construction industry, where employees have to work outside, sometimes in real hot conditions. Here's a 5A1 citation taken from a heat illness violation. It reads there, the first part reads the same: the employer exposed employees transferring household goods from a residence to an enclosed trailer to the recognized hazard of excessive heat. At the time of the incident, the heat index reached 112 degrees Fahrenheit, right? So there you have it. You've got an allegation that employees were working in excessive heat. That's the hazard, right? There was exposure. Employees were performing this task in that heat. And heat illness, of course, can result in serious injury or death. And so all of that, again, is sort of encapsulated in this phraseology in the heat illness general duty clause violation. For feasible means of abatement, again, you're having sort of a laundry list of things that OSHA points to for employers to consider in protecting employees from heat illness prevention program. You're going to hear me talk again about having a written program there, so just give me a second. Heat illness prevention program, hydration, obviously, work rest regimens, employee rotation, training, supervisor checks on employees, shade, cooling areas, heat stress monitoring, all of those different things that are out there in terms of sort of best practices are going to be listed in a feasible means of abatement. Again, OSHA is going to need to prove that each of these will materially reduce the hazard, something that sometimes can get difficult for them to prove. But nevertheless, these are the things that, as an employer, you should be thinking of to the extent you have employees working in hot environments, whether they be indoor or outdoor, frankly. We're seeing more and more attention of OSHA on indoor heat as opposed to outdoor heat as well. These are big issues, and there was a significant case, sort of trying to tie in industry recognition with a general duty clause citation for heat. There was a significant case that was litigated recently where OSHA essentially cited to a 2-page publication put out by a trade association related to heat and listing some of these measures, and OSHA asserted that 2-page document essentially constituted industry recognition of the hazard, and therefore that prong of the general duty clause was proven. So this is out there. Again, just like the other two, if you've got heat illness exposures, you're going to want to have a written plan, and you want to consider all of those particular means of abatement that are included on this slide, as well as potentially others that are applicable. Okay. We talked about ergonomics. We talked about workplace violence. We talked about heat illness. Let's kind of close a little bit and talk about COVID-19, because that is obviously something that is big right now. We're starting to see some citations from OSHA. I don't think we've seen a general duty clause violation yet from OSHA, but we're starting to see more increased activity from OSHA. So let's talk a little bit about COVID. Okay. OSHA states, and this is obviously true, that there are basically a few different enforcement mechanisms that it has to deal with the COVID-19 pandemic. They're all listed there. The general duty clause, section 5A1, we'll talk about that in the next slide. But just so you know, there are other standards that are applicable. Most directly, you're going to have the variety of personal protective equipment standards and respiratory protection, right? Eye protection, respiratory protection, hand protection, the general PPE standard, right? So those standards all could be applicable and sort of potentially cited in a COVID-19 situation. There are some other things listed here, HAZCOM, if you're doing cleaning with respect to hazardous chemicals used, and of course, record keeping and injury and illness reporting. And that has been a huge issue for a number of employers. How do you handle, how do you address, how do you deal with a COVID-19 case in terms of whether it's work-related and recordable? So OSHA has a number of standards that are directly applicable, but it doesn't have, going back to the very beginning of the webinar, it doesn't have a COVID-19 standard. So it can also cite under the general duty clause, okay? The general duty clause is out there. OSHA has stated publicly that it is available. And so it's something that the agency could turn to and start issuing citations. This is the problem, though, and this is the reality with COVID-19. Some of the things that we were just talking about in terms of industry recognition, right, particularly, or employer recognition, it's hard to make that out right now because COVID-19 is changing so rapidly. The information that we have, the protective measures that we have out there are changing so frequently. It's hard to say that something out there is recognized by the industry, right, as a hazard, and subsequently whether there are feasible means of abatement to reduce that. So it's really going to be sort of a tricky, difficult thing for OSHA to make out, given the fast-moving nature of this pandemic. The other question I get a lot, and I do mean a lot, is use of CDC recommendations and OSHA guidelines with respect to the general duty clause. Multiple times, almost a day, I'll get a question from a client that says, look, can OSHA cite me under the general duty clause for not following the CDC recommendation? Okay, get that a lot, and probably you guys are all thinking about that in your own head. This is what OSHA's position is on the use of the CDC recommendations. It's consistent with some of the framework we talked about earlier. The most current CDC guidance should be consulted in assessing potential workplace hazards and to evaluate the adequacy of an employer's protective measures for workers. Where the protective measures implemented by an employer are not as protective as those recommended by the CDC, the CSHO or the compliance officer should consider whether employees are exposed to a recognized hazard and whether there are feasible means to abate that hazard. Okay, what does that mean in layman's terms? In layman's terms, OSHA is basically saying, look, OSHA, when you're out there inspecting, you've got to consider the CDC recommendations. And therefore, employers, as you are implementing protective measures, you've got to consider CDC recommendations. You've got to consider other guidance that's out there that may be applicable to your industry, right? What I tell clients is you need to look at the CDC guidance. You need to figure out how it applies in your work environment. You should implement those measures that are feasible to be implemented, right? Some things you can do, some things you can't do, depending upon what your jobs actually entail. And then if you can't implement something, document the reasons why you can't. Essentially make a determination that these particular control measures aren't feasible. You can't stay 6 feet apart, whatever it is in your work environment. Make those findings. And then if OSHA comes in to conduct some sort of COVID-19 inspection, you'll be able to demonstrate to them that you've been thoughtful about it. You've reviewed the CDC guidance. You've implemented what you can, and what you can't, you've documented why you couldn't. So that's a really important thing to be doing right now if you're not otherwise doing it with respect to COVID-19. And I would also note, with respect to COVID, it is critically important that you have some sort of written COVID-19 compliance plan. OSHA is asking for that in every inspection. So if you don't have something like that in hand, ready to give, it's been reviewed, that's in good shape, please do so now, because in the COVID world, that is the first step in surviving a COVID-19 inspection. And so with that, I don't know, Jim, are there any other questions? I know we just have a couple minutes. Happy to take any if we did. If not, I certainly appreciate everyone listening in and hopefully learned a little bit about the general duty clause.
Brad, that was excellent. At this point, I don't have any questions.
Great.
I will. We've got a couple minutes, so I'll keep an eye out for questions. But I'd be remiss. Matt, one of our attendees, wanted you to hear "Go Raiders." Now, so I did that for Matt, and I did that for Matt, and I didn't understand why he typed that in.
Yeah, and Raider Nation.
All of a sudden, I noticed the yellow thing behind you, and so I would be remiss in not letting you know that you're. I am a lifelong Cleveland Browns fan.
Oh well, yeah, no, that's
so anyway.
We have a history.
We have a history. All right. Well, I'm going to. We don't have any questions, Brad. I just want to thank you. It was excellent information. And for our attendees, I just want you to know that this webinar has been recorded, and it will be located on the ASA website on the ASA safety pages at some point in the near future, so you can access it or use it in your lunchtime programs at your companies and what have you. So look for that. Brad, if anybody wanted to get a hold of you, I assume it's okay. Do you have any, how would they get a hold of you?
Absolutely. Yeah, if I think on the webinar deck, it's my email should be there, but it's Hammock, BHAMMOCK @littler.com. Feel free to shoot me an email, and I'm happy to chat.
Fantastic. For those that are still on the call, just watch for our upcoming webinars. We have one set up in November that'll be covering what to do when the inspector comes, type thing. So look for that presentation coming up. And again, my sincere thanks to you, Brad. It was an excellent presentation, a lot of good information, and thanks to everybody for attending. Have a good one, folks.
Thank you.